Welcome everyone to this webinar of the Women's Studies in UCC. Today we're lucky to have Maeve O'Rourke, Dr. Maeve O'Rourke from the Irish Centre for Human Rights and at the NYG Galway. And she's going to talk about the Clann project, Ireland's unmarried mothers and their children, gathering the data. So Dr. O'Rourke is going to talk a bit about the project, the Clann project, and then we're going to have a discussion, a Q&A. This is going to be more of an informal webinar rather than a lecture. So we're going to have a bit of a background introduction by her, and then we're going to start straight away with the discussion. So now Maeve is going to introduce the Clann project and the website of the Clann project. Thank you so much, Maeve, for being with us today.
Great, thanks so much, Ciara, and I'm really thrilled to be here. It's really nice to see the faces, as I said. And I did, yes, suggest that we actually focused mainly on a Q&A because, as you all will know, the issues and the topic are just vast. And I do sometimes find it difficult within a short space of time to feel like I've covered everything that people might be interested in. It's hard to even know where to begin. So yes, I will briefly introduce the Clann project, and then ideally we'll go straight into a decent Q&A, and I'm really thrilled to be here. So I'm going to just share the website of the Clann project to be able to talk it through just a little bit with you. So sorry, 1 second now. I can't actually tell if this is sharing correctly.
No sign of sharing.
No. Now?
Yes.
Okay, fantastic. So now we're on the homepage of the Clann project. So I actually just want to give you a sense of the logistical framework, really, of the project through the website. It's a really important resource, and I absolutely have to give credit to Claire McGettrick for creating these amazing websites. This one, you'll probably, anyone who's been on the Justice for Magdalene's research website and the Adoption Rights Alliance website will notice that they're all similar in their layout. And one of the amazing things about the voluntary work that I have done with Justice for Magdalene's research, including, of course, Claire McGettrick, Mary Steed, Jim Smith and Catherine O'Donnell, and also Adoption Rights Alliance, and the amazing team of volunteers that work with Adoption Rights Alliance, is the real commitment to providing accessible information and to acting transparently. So these websites have always been a crucial part of the, I suppose, research, the outreach, and the advocacy. So this is the website of the Clann project. And just to, I suppose, show you in very basic detail, what we wanted was it to be a place where anybody from the general public wanting to find out more about the system of forced family separation during the 20th century could go to find out what it was that the Clann project was doing. But also we wanted it to be a place for people who were interested in participating in the Clann project to find out more about it at the time that it was gathering witness statements, and then after the witness statement gathering process finished, a place where people could come back to see what was happening next, and I'll take you through the archive. So, sorry, the first thing to just show you on this homepage are these information videos. And this was one of the first things that we did when we set up the Clann project, and after we had organised how it was going to work, we created short videos as a form of outreach and sent those videos with an information, a detailed information pack, including full ethical protocols, as well as information forms and sample questionnaires, out as far and wide as we possibly could within both Ireland, but also abroad, using the entire network of Irish immigrant services that we could find, as well as survivor support services, to spread the word and to it really depended on the organisation. Some of them actually held information evenings, information afternoons, at which any of us who could spoke as well, but where they would play the videos as well as providing the paper-based materials to people. So that's just important to say there. And now I will tell you what exactly the Clann project is about, and to do so I'll just take you into the About page of this website. So yeah, so essentially the Clann project grows out of the experience that Justice for Magdalene's research had between 2011 and 2013 of doing a parallel process of inquiry of our own at the same time that the MacLeese Committee was doing its inquiry into state involvement with the Magdalene laundries. I am a voluntary member of the Justice for Magdalene's research group since 2010, and we found, I mean, we were advised in 2011 after the government had set up an inquiry that was non-statutory, that was staffed by senior civil servants from all the government departments involved with Magdalene laundries. We were advised by a very senior lawyer in London who worked with the government. We were advised to do our own inquiry because instead of sitting back and waiting for the outcome of a process that we felt very much did not meet the state's obligations to conduct an effective investigation into allegations of human rights abuse, instead of sitting back, we should actually gather what evidence we could, compile it, which we did, over 800 pages of witness testimony and overall 5,000 pages of archival and other evidence relating to abuses and the state's responsibility for them in Magdalene laundries, and we compiled that into a 150-page legal argument, as well as providing those witness statements and all of the accompanying evidence to the MacLeese Committee, and ultimately publishing it to the extent that we could. And that's where the UCD/Justice for Magdalene's Research Oral History project grew out of. And that 150-page legal assessment of all of the evidence that we had gathered proved absolutely vital for advocacy purposes in February 2013, when the MacLeese Committee released a report that really absolutely did not have findings about the actual treatment of girls and women. Instead, its findings were to do with state responsibility. So it was really important to have that parallel process done, and our alternative report available for advocacy purposes. Okay, so I'm kind of keen to get back. It's funny just staring at a website here, so I'm keen to get back to everybody. So very quickly, I'm just going to take you through then the Clann project. So Justice for Magdalene's Research and Adoption Rights Alliance are essentially sister organisations, in that the founders of them cross over between the two organisations. And so two voluntary groups, ARA and JFMR, got together in 2015. First of all, actually in 2014, to make submissions on the proposed terms of reference for the Commission of Investigation into Mother and Baby Homes. But then in 2015, once the commission was set up, once we could see what the terms of reference were, we got together with Hogan Lovells, one of the world's biggest law firms. We didn't have the capacity anymore that we had very much overspent our energies, but also the reach of forced family separation is so much broader than Magdalene laundries. We didn't have the capacity to gather the evidence ourselves totally this time, and so Hogan Lovells were looking for pro bono work to do and offered solicitors to help to gather the evidence in order to do a similar parallel evidence gathering and ultimately advocacy exercise. So I'm just going to look here, what is Clann? You'll see that, well, between 2015 and 2018, it provided assistance to anybody who wanted to give evidence to the Commission of Investigation into Mother and Baby Homes. It gave free legal assistance, and then ultimately we produced a group report, and all of this is available on the website. In the end, from speaking to about 150 people, over 80 witness statements were completed. Those witness statements are very detailed. And so it was a long and arduous process, and the public group report was compiled with the assistance of lawyers from both Hogan Lovells, but also over 20 barristers who provided free analysis of the legal frameworks that are relevant to the forced family separation issues through the Bar of Ireland's Voluntary Assistance Scheme. Why we decided to establish Clann? First of all, the remit of the Mother and Baby Homes Commission, as everybody knows, is very limited. It's limited to the 14 mother and baby homes and a representative sample of county homes. Whereas the issue of forced family separation, we believed through our research and submitted a list to the Mother and Baby Homes Commission involved, it says here 170 plus, over 180 institutions, agencies and individuals. And I think it's very clear now that we can see that adoption and forced family separation as an issue is far broader and has not yet been properly addressed, not acknowledged yet as a site of abuse in and of itself, and certainly not investigated, and information hasn't been provided to those affected, and of course not to the general public either. Then, although so there was an issue around the commission wasn't going to pay for people to have lawyers represent them, and so we did want to provide people with the assistance that they might wish to have to give their best evidence to the commission, and most importantly as well, to keep a copy. Because the commission is not actually providing and has never provided a copy of people's evidence that they've given. We wanted to bring people together so that collaboratively they could essentially provide corroborating and supporting and relevant evidence in relation to each other. So to provide some power in that way, as well as being able to bring together all of the evidence gathered and analyse it from a legal perspective, including constitutional law, European human rights law and international human rights law standards. And the final point that you'll see there is that we were concerned that the Mother and Baby Homes Commission, from the very beginning, it was clear did not have plans to hold public hearings. And so we wanted to have this project provide some sorely needed transparency. And you will see what's key here is the archive. So if you go to view, contribute to the archive of the Clann project, you will see that there is the copies of correspondence that Hogan Lovells had with the Commission, which is very interesting in relation to their procedures in particular, also to the request of Adoption Rights Alliance and Justice for Magdalens as the Clann project for a public hearing in front of the Commission and the refusal of that request. You will see the whole archive of the previous Justice for Magdalens political campaign. You will see the Magdalen oral history. You'll see archival newspaper, Magdalen Names Project, and an absolutely crucial part of that archive that is coming are anonymised witness statements gathered as part of the Clann project, gathered by the solicitors and being anonymised at present by the Clann project to the extent that people wish to put them online. The last thing I just want to show you, because there's so much you can see here, is the ethical protocols. So just here, so a lot of work, again, credit in particular to Claire McGettrick and her very survivor and adopted person focused approach to all of this research and advocacy work that Adoption Rights Alliance and Justice for Magdalens has been involved in. Are the ethical protocols. They were absolutely painstakingly devised and may well provide an interesting resource for anybody wishing to know more about the technicalities and nuts and bolts really of how the Clann project operated and still continues to operate. Now, I'm actually going to come back into the teams if I can. Yeah, I think I come back here because really, yeah, I just wanted to show the website, show a few of the nuts and bolts, but I'd really enjoy now a proper chance to respond to questions that people have, because I know that a lot of people here are already very knowledgeable. And like I say, it's just an absolutely vast amount of information that I could choose to talk about, but might miss what people are particularly interested in.
Thank you so much, Maeve. This is a fascinating project, and it's really timely and important, as we know from the whole debate around the sealing of archives. So I just wanted to ask as a first question, what is the state of the situation now with this sealing of the archives? I know there was a kind of backtracking from the government, and they said that they give access to the survivors. So if you could give us an update.
Yeah, I will, absolutely. And it's worth noting, I suppose, that it was on the Clann Project website, and you'll still be able to see the information about it, that we started the email campaign that caused the whole fuss, I suppose, around this bill that Minister Roderick O'Gorman brought in. And yes, it's worth giving a bit of background to that, because that brings us to where we are now. So the sealing, and sealing really has to come in quotation marks, because it's actually not a legal term. Now, it was as a term seen in the 2019 Retention of Records Bill, and the evidence of Fred Logue, who many of you will know, an excellent data protection solicitor, when he gave evidence to the hastily convened emergency session of the Education Committee of the Oireachtas at the end of 2019, which was convened by Fiona O'Loughlin and Lynn Ruane as a really key effort to stop that bill in its tracks. His evidence was that sealing has no legal meaning. It shouldn't be in this bill. What does it mean? And in any event, it's completely contrary to EU General Data Protection Law, or Data Protection Law. So that's important to say. But that de facto censorship and sealing of records is a pattern that we have seen for decades, that really has very little legal basis, and it's worth pointing out a few things. So the Ryan Commission, the Commission to Inquire into Child Abuse, operated under the 2000 Commission to Inquire into Child Abuse Act. And the submissions, certainly my own and others' submissions, which are all on the Justice for Magdalene's Research website about the Retention of Records Bill 2019, goes into a lot of detail about this, because it was claimed last year, when Minister for Education at the time, Joe McHugh, brought in the Retention of Records Bill, which sought to seal all of the records contained in the Ryan Commission's archive and the archives of the Redress Board and the Review Committee. It was claimed that actually back in 2000, the law that was brought in then actually guaranteed everybody that everything in those archives as a whole would be destroyed. And that actually, by coming along with the Retention of Records Bill, even though, yes, things were going to be sealed for 75 years, it was actually a big favour to people. We were doing right by everybody who is in a vulnerable situation, because instead of destroying things as they were going to be, we were preserving them, albeit not allowing even those affected to have any access. But this was a great step. It was very positive. Now, it is not true that the 2000 Commission to Inquire into Child Abuse Act envisaged either the secrecy or the destruction of everything gathered by the Ryan Commission. Originally, under that act, it was envisaged the Freedom of Information would operate. It was in the 2014 Freedom of Information Act that then, in a schedule, public body was defined as not any longer including the Commission to Inquire into Child Abuse, save in relation to its own administrative files, but certainly not in relation to its archive as a whole. Certainly there was no provision that anything that went to the investigative arm of the Ryan Commission would be destroyed, let alone made secret. And so in my view, looking back when I was giving evidence last year in the Retention of Records Bill, and like I say, there's a lot of detail in writing that I can't go into now, but in my view, the kind of censorship and sealing is a progressively advancing notion rather than one that was always the case. And so that's very worrying to me. And so that was one thing that was very worrying, and really that Retention of Records Bill, I think could have gone through had it not been for, you know, the immense, or at least could have progressed more had it not been for the immense efforts of some survivors, and like I say, those politicians on the Education Committee who held an emergency evidence gathering session. There hadn't been a chance for oral evidence to be given in 2015 when the Retention of Records Bill was originally devised. Myself and a group of academics, including James Gallen in DCU, Sinead Ring in Maynooth, Mairead Enright in Kent, and Sarah in Birmingham, and Sarah Ann Buckley in Galway, we FOI'd any records relating to a consultation in 2015 on that Retention of Records Bill, and it turned out the department had written an invited comment from the religious and from survivor groups that it wished to contact, but it didn't have, public evidence given by survivors. There was some public evidence given by officials, and the narrative was not challenged that this was what everybody was promised, this is what they want to see, secrecy of all records, including from themselves. Okay, and the last thing just on the Retention of Records Bill as a background, that's I think very important is last year at the end of 2019, I brought the spokesperson from the Stasi Records in Berlin to Galway to start to work with a small initial working group of survivors, academics, on what might be the bones of legislation to establish a national dedicated archive of historical care-related records. And she went on to RTE Radio, onto the Today with Sean O'Rourke programme, and she was followed by Judge Sean Ryan. And the question was put to Judge Ryan, consistently, but why should the survivors not have access to their own files? Why should survivors not have access to their own testimony? And he said, after quite a lot of pressing, my report is the history. So I think that's important to have as a background. Then also in 2019, the 2016 Adoption Information and Tracing Bill was very much pushed through the Seanad, but again, Claire McGettrick's amazing coding skills and setting up an email campaign that allows you to open it up in your own email server. Therefore, all of the emails come from different IP addresses. Therefore, it very much does overwhelm the political representatives. So she set up that kind of an email campaign with Adoption Rights Alliance in relation to the Adoption Information and Tracing Bill. And there was also a lot of other, of course, advocacy around it. But what a lot of people didn't focus on, because the focus was all on birth certificates, was that actually Section 40 of that bill, and this is in relation to all adoption and informal care placement records, said that any person seeking their own files, and notably it didn't have any provision for mothers, it was only to do with people who are grown-up adopted people or people formerly in other informal care arrangements, anyone seeking their file could not have their file, but would be entitled instead to a statement created afresh by a social worker containing only non-identifying information taken from their file. And that was not discussed, it was not debated, it was like completely ignored, because all of the focus was on, can we possibly constitutionally ever give all adopted people their identity? That is a really important question. I've published a legal opinion with Conor O'Mahony and with a number of other lawyers saying the Constitution provides immense latitude, as does the GDPR, for the Oireachtas to legislate to give every single person their birth certificate. That yes, there are privacy rights of all parties that need to be considered, but they can be interfered with and can only be interfered with where it's proportionate. And it can be proportionate to ensure that an information session and a properly resourced National Adoption Contact Reference Register would protect the privacy rights of all those in relation to contact and in relation to information, particularly bearing in mind that birth certificates are public documents and the abuses that we know happened. Everybody has access to their own identifying information. But that was the debate happening, and there was no focus on the fact that in relation to everything other than the birth certificate, it was all going to be essentially sealed. Now, then we come to the Mother and Baby Homes Commission, and because we in the Clann project have been working for 5 years in correspondence with the Commission through Hogan Lovells and also with individuals who are in contact with the Commission, we knew that the Commission was operating a blanket restriction on all access to personal data by those affected by abuse. It was issuing letters post-2018 saying the amended Section 39 of the 2004 Act says that we can restrict your Article 15 right of access to your personal data under the GDPR to the extent necessary and proportionate to, or necessary to safeguard the functioning of our commission, and we decide that in your case that's necessary, but never providing any reasons. They had said from the beginning people couldn't have access to a copy of their transcript, and they had refused all requests for public hearings. And so it was no surprise to us that when the minister brought in this, what he claimed was this mini bill that just had to do this little administrative thing, which was make sure the commission didn't redact anything before sending it to him and give TUSLA a copy of the database, the Excel spreadsheet that the commission had created. It was no surprise to us that in all the briefings he was saying, and the reason I have to give some of the thing to TUSLA is because when I receive it, it'll all be sealed for 30 years. So that has no basis in law because there is no 30-year ceiling in the 2004 Commission of Investigation Act. Where 30 years comes up is there is a provision saying after 30 years from the time that the minister receives the whole archive of a commission under the 2004 Act, it will go to the National Archives. It doesn't say that in the meantime there will be no access. What is more troubling and hadn't come out in the debates, but was mentioned in a PQ because my colleagues and I in Clann with Gary Gannon, way before we did the email campaign, did PQs to try and draw the minister's attention to the fact that his claim he would seal was contrary to the GDPR. So we had done PQs, and what he said back was, actually I have to seal it because of Section 11. Now that is a massive problem in the 2004 Act. And the High Court has found now pre-GDPR, so we have to remember GDPR puts paid to all notions of sealing, but pre-GDPR, the High Court had found in cases by families of the Dublin Monaghan bombing victims that they could not have transcripts out of that archive because Section 11 says it's a criminal offence for anything gathered in private by a commission to be published, save to the extent that the commission has, during the course of its inquiries, decided to give evidence out to people. Now it has broad powers to do that. In fact, it's obliged under Section 12 to give any witness any of the evidence which, in its opinion, that witness should have. But to the extent that it doesn't do that, when it gets to the end, Section 11 is a huge issue. And I believe it will also be something akin to Section 28, subsection 6 of the Redress Act, which is to gag, essentially, survivors from repeating anything that they said. It is the justification the Commission gives for not giving anyone a transcript of their evidence. It says it's there's a criminal offence prohibiting publication of anything given to us in private. We can't give anyone their transcript. Now, again, the GDPR puts paid to a lot of this, but there are massive problems with the 2004 Act. I and others, Adoption Rights Alliance, Justice Magdalens Research, pointed it all out in 2015 that this act was not appropriate for this inquiry. We got nowhere with that. And so the U-turn, in my view, is hugely significant, hugely. The two things. Number one, that actually we recognise GDPR exists and EU law is supreme over all conflicting Irish law. That is relevant now to all abuse archives. I mean, those relatives, for example, well, it depends. I mean, of course, GDPR is not perfect. It doesn't necessarily do much for you in terms of disappeared relatives information, but every archive in the state now has to comply, access to it has to comply with GDPR. The question is how the state is going to start to implement this. It's a huge question. And then the other thing that was huge about the announcement was, of course, we recognise there is actually a need to not have all of these records of so-called historical abuse scattered here, there and everywhere. We recognise there is a need actually for a dedicated national archive. Now, there's loads of things that need to be done in the meantime. I would argue that the Freedom of Information Act absolutely has to be strengthened because at the moment it doesn't really apply to historical records. It should be. People should have access. They shouldn't have to wait for the creation of a national archive. And so there's a lot of work to be done between now and then. And then, you know, the design of a national archive has to be completely centred on the people affected. But it's huge in my view. And I do think that the minister was completely blindsided by what his officials had asked him to do in just bringing the simple bill in, and by giving him and by repeating all of the briefing notes that said, you know, we have to do this, we're doing everyone a favor because I'll be sealing everything for 30 years. I think he didn't know what he was walking into, but now is the time for the politicians, and hopefully they have started to realise that, I suppose, the official mechanisms have been operating away in the background, getting more and more secret, and it's actually politicians' job to regulate the use and access to information, and it's totally within their powers, including within their powers to compel the production of privately held archives. So I hope that we're going to see movement. That was an extremely long answer to your first question.
Thank you for the update. Yeah, I guess that bears the question, you know, why so much secrecy, and why so much also in relation to this adoptees' rights and birth rights. Why this? Because I was hearing that the RTE podcast you did with Mary Herney, and she was talking about you were talking about this continuing abuse, right? This is not historical. You said it's something that's continuing today, and it continues in the form of abuse of the people who are looking for information about the circumstances around their birth and their parents and natural mothers and so on. So why so much fear of uncovering what happened? Is it because many of these people were part of the system of illegal adoptions are still alive and they might be put to trial? There could be some implication for human rights law. How would that look like?
Yeah, I mean, it's, you know, it's hard to speculate as to what, if there is one driving force behind it. I don't think there is. I think it's a huge combination of things. I think possibly at the legal advice level, whether it's advisors to private organizations or, you know, as much as the state, there is an issue that if someone only obtains information now, the limitation period in the statute of limitations only begins to run from the date of knowledge of what happened to them. And so if they didn't know that they were illegally separated, if they only see their file and if they only meet their mother and realize that for the first time, then there is, you know, they're not out of date for bringing a civil claim. Civil claims are made easier the more access you have to administrative archives as well. This is so clear from the Mau litigation in the English High Court, where in 2012, Mr. Justice McComb in the High Court allowed a group of survivors of torture in Kenya in the 1950s to proceed in their claim against the state because actually they had access to the whole of the state's administrative archives, which had actually previously been kept, and the state pretended they didn't have them, but they actually did. And that case then settled because he wouldn't accept the limitation period as a defence. Now, in England, unlike in Ireland, there is actually a provision in their statute of limitations allowing cases to proceed if it's equitable to do so. So a court can disapply the ordinary limitation period. We actually don't have that, so that's an added barrier. But the issue of people accessing what is actually evidence of torts, of constitutional violations, of other human rights violations, I think is key. Now, I just don't know to what extent, but I think it's there. Other issues are to do, I think, with social workers and the lack of guidance and proper interpretation of law that's been given to them. And that's, of course, also a lack of primary legislation telling them that they can and that they must give people their information. So there's a real lacuna, and I guess it kind of, perhaps going back to what I've just said, suits those who were in positions of authority. But, you know, they're like social workers. Now, first of all, social workers are completely under-resourced and overstretched and are not trained to manage records. So that's an issue in and of itself, but there clearly has not been proper guidelines, not only under the GDPR and now our Data Protection Act 2018, but the data protection laws that existed before then. So what is clearly not properly understood, and of course, even if it was understood by one individual social worker, who could blame them for, you know, if like, what if one individual social worker understands the law, but they're, I mean, like the whole system has to be instructed to operate properly. Like mixed personal data is a thing, is personal data. So, and both people have a right to access it under data protection law. So like records of your medical treatment that name your doctor are your doctor's and yours at the same time, and both of you have the right. Now, so that's the first thing that's not understood, and I don't think. And then the balancing test comes in. Now, the issue that seems to be a huge issue since the GDPR came in, that people are using to justify redacting every single thing that is not your name and something that only relates to you, is there's this notion that the GDPR requires us to protect everybody else from you knowing who they are, even if they did something relating to you or they relate to you. And that comes from Article 15.4 of the GDPR, which says the right of access shall not adversely affect the rights and freedoms of others. But the GDPR can simply not have been intended to do away with the rights under both the ECHR and the Charter of Fundamental Rights of the EU. Of course, the GDPR derives from the Article 8 Charter right of protection of your personal data and right to access. And as we all know, the cardinal rule in relation to when a state can interfere with your right to privacy, i.e. like, and that would be, so when, if I have a right, I can actually maybe not have my data, or when minds mix, someone can have it, even though I would prefer them not to, is if it is strictly necessary in pursuit of a legitimate aim in a democratic society and proportionate. So I would argue there has been like absolutely no engagement with the question of whether it is proportionate to give someone the information that is central to their identity, bearing in mind the importance of that and the balancing and the other provisions like assistance information that can be given to other people, while you also respect the identity rights and needs of that person who's seeking their data that is mixed. No consideration of the actual balancing. And equally, whether it is necessary and proportionate to prevent someone getting the most fundamental information about themselves simply because you want to protect. I mean, anecdotally, we're just hearing such distressing things from people who are adopted, like, we need to make sure that your entire extended natural family might not be, you know, disturbed or a bit taken aback, or that they're all okay with you knowing who you are. Like, that is a strictly necessary and proportionate interference? What is the balancing? So there has been just an incredible lack of engagement with the actual legal rules that have existed since the foundation of European human rights law. You know, on the right to privacy, yes, the fact that it's not absolute, but the fact that the state can only interfere, but can only interfere in those circumstances. And so that provision in Article 15.4, that you've got a right of access under the GDPR to the extent that it doesn't adversely affect the rights and freedoms of others, I think just has to be. I can't understand now. You know, it's a new provision. It's not been interpreted yet by the Court of Justice of the European Union. I just fail to see how it couldn't require interpreting in light of our existing human rights. And the final thing I'd say is, like, people who don't know who they are, and TUSA has their file, they might be one of the people who was actually registered as the natural child of their adoptive parents, and may well have even grown up not knowing they were adopted at all. And if they are told now they're adopted and they're not allowed to know who they are, or anybody who is not allowed to know who they are, I mean, I don't actually understand what the right of protection data means if it doesn't mean to know who you are, because in a digital age, the GDPR is all about ensuring that we as individuals retain our individuality, our personality. Like, dignity is Article 1 of the Charter of Fundamental Rights of the European Union. It shall be inviolable. And data protection law in the EU comes from Germany. And I do really feel, getting philosophical about it, that adopted people are being treated as means to other people's ends. Oh, we need to know if everybody else is okay with you knowing who you are, rather than as ends in themselves and as people in their own right. And that is how the Irish system of adoption treated adopted children from the very beginning. And that is how they're still being treated. And yeah, and I don't know, I think it couldn't be more serious, more fundamental. And the changes that we need to see are absolutely vast, but I do think they could happen overnight if only the government would take advice from people who actually understand, and perhaps are distant from Ireland, but understand information and data protection law.
Are there any questions on all this topic for Maeve?
Hi Maeve. I really admire all the work you do. My name's Breed, and I have no legal background at all, high up or low down, but just two things. One is like saying Joe McHugh was blindsided. In fairness, he has access to a lot. Sorry?
Roderick O'Gorman was blindsided.
Oh, sorry. They have access, and I mean, he's a legal person himself, isn't he?
Well, yeah, sorry. Yeah, he shouldn't have been blindsided by the GDPR. You're completely right, yeah.
And the other thing was, I was just thinking as you were saying, like the Boston tapes, you know, does that have any bearing on, you know, on how that information was collected? But then it was like, is there any can you sort of?
I think that, but I'm not, like, I only know a little bit about the Boston tapes, and I know that it just maybe gave everybody who does oral histories a fright. I think the issue was with what they promised that they couldn't actually deliver, because once the existence of the tapes was known, the American legal system kicked in, so they should never have, I suppose, promised. But I have to confess, I don't know the full details of it. I think it goes to the ethics of collecting an oral history and what you, the consent and what you claim to promise to people, that, and needing to actually have known what that legal system could do. And yeah, but you're right about not being, I mean, the blindsided thing, yes, I absolutely take that point. I suppose now I think he was blindsided. I don't think he should have been. I think that taking on the portfolio of Minister for Children, he should have read the report of the Collaborative Forum, the Clann report, like all the consultation reports that came before the Collaborative Forum. He should have met with the Collaborative Forum. The first thing that he did, it still doesn't have a new chairperson. It hasn't convened as a group, as far as I know, to date since he came in. But I think he was okay. Not that he should have been.
Yeah. Okay. That's right.
Because like the response was, but we're not. But it's not. But we're not. But you're like, but your job as politicians is to respond to a situation that has developed, where you have the unique ability to set out in law what is supposed to be happening here. And it's not good enough to say, like, well, we aren't the ones who are making all the evidence secret. Like, it's your job to make sure that it's not, because this couldn't be more serious. And you're right that he also is an EU law lecturer, and there was a very disturbing issue with the Attorney General's advice, very disturbing, in that so the whole way through this debate, and it was only 2 weeks long, and in a way that was a gift for a campaign on records, because you never get a focus on records ever in the media, in the Dáil and Shannon. So there was no distraction there weren't, the media often prefers to focus on the individual stories of the forced adoption in the first place. And as I'm blue in the face saying to people, like, part of the reason they're still so upsetting is because people still can't access the information, but you just don't get that focus on the technical thing like that. So it was a golden opportunity before the report came out to get everybody focused on archives. And the issue then, the complicated issue, was that they were saying, well, this bill doesn't seal the archives, and we were saying, but you need to unseal the archives with this bill because you're in the Dáil and Seanad. You could simply just say, for the avoidance of doubt, the Civil Services Department of Children will be implementing the GDPR. They don't mean what they say. Like, I actually read their press releases as meaning what they said. And so that's what legislation is there for, to say, excuse me, you will, for the avoidance of doubt, interpret or implement the GDPR. Now, the minister kept saying, we can't do that because the GDPR doesn't apply. Now, he's an EU law lecturer. Equally, the new Attorney General, to my knowledge, before he took that job, was Facebook's lawyer in Europe, an EU data protection law expert. And not only did the minister say repeatedly in the Dáil and Seanad, the GDPR doesn't apply to this archive, he said the Attorney General has advised that the GDPR does not apply to this archive. And it was only after the whole debates were over and the bill had gone through that the Attorney General came to Cabinet and said, I didn't give any advice like that. It was actually people seconded from the Attorney General's office in the Department of Children who had advised. It wasn't, and like, but he didn't, it was the Tuesday after the whole thing was over. And again, of course, like, when the minister was relying on so-called Attorney General's advice, it was nowhere to be seen because there's this, you know, crazy procedure of, or like practice, not that it's legally mandated at all, not to produce Attorney General's advice. So that was extremely, extremely worrying and just distressing for everybody. And also the tone of the debate was horrendous. You know, the Clann project was defamed for 11 minutes in the Seanad by Senator Barry Ward, saying the people who did the email campaign that said in the subject line, don't bury the records, Minister, which was the Clann project email, which hyperlinked, because I wrote the text, to all of his statements that his department would be sealing it. It didn't say that that bill sealed it. It said the bill should make sure that his statement said he was going to do. And for 11 minutes in the Seanad, instead of actually speaking about anything else, said that we were willfully misleading and misinforming the public and the senators and TDs, and that we had deliberately re-traumatized survivors of mother and baby homes and forced adoption, and that we had led them up the garden path. And like, themselves know that they're not having access to their evidence. The people themselves know that they requested public hearings and that they were denied them. Like Philomena Lee, who participated in the Clann project and spoke publicly about this, she requested a public hearing. And imagine if she had given one, how many people might have requested them afterwards, and what a different situation we might have been in now. And it's been constantly said in relation to the records, the physical paper records. Minister O'Gorman has said it, Minister Joe McHugh said it last year, I've heard it in response to my request for what's in the Macaleys. Oh, I didn't even say that at the very beginning. That was part of the practice as well, the pattern. The Macaleys archive of all the state documents on the Magdalen laundries doesn't even have legislation underpinning that inquiry. It's been held by the Department of the Taoiseach for safekeeping and not for the purposes of the Freedom of Information Act. And a woman with pro bono lawyers managed to get a decision from the Information Commissioner earlier this year that that is an unlawful interpretation of, well, it's just unlawful. They are holding it for the purpose of the Freedom of Information Act. But every time I've applied to that, and also in relation to the mother and baby homes and in relation to the redress, the Ryan, all the government keeps saying, we just have copies. You can actually still go and get the stuff from their original locations. But like, they won't hand out the index or the finding aids. And the Freedom of Information Act doesn't actually work properly in respect of historical records. Things aren't in the National Archives because, as the Forza report on National Archives revealed last year, the National Archives only has 25% of the funding on a per capita basis that Denmark and Northern Ireland have for their national archives, and can actually only work with 4 government departments, and a third of its entire limited holdings still aren't catalogued for public access. So it is not realistic to say that people can find the information elsewhere. And I just, I've just ended up on another rant. I just feel that people are so badly served and almost gaslit, telling them that what you know, you don't. There is no problem here. It's completely normal. And then the editorials in the Irish Times saying these inquiries have to happen in private, as if they've never, well, they clearly have never looked outside of Ireland to see how an inquiry into human rights violations happens and is supposed to happen. They absolutely do not have to and are not permitted to happen completely in secret from the people who are affected themselves.
And is there anything practical that we can do, you know, as ourselves as just a regular citizen? You know, what could we do? Because I just feel so strongly about it.
Yeah, I think that researchers definitely need to get more active in using the Freedom of Information Act and trying to get their heads around and trying to challenge, and also what is going on with the National Archives funding, the use of the Act, that is actually, I do feel that, you know, records, archives, they are the terrain of academia, and it's not good enough that, you know, it's all secret and the people who kind of have the knowledge of how these things should work aren't up in arms about it. So that's one thing that you actually can, individuals can use that act and they can appeal to the Information Commissioner. You actually can begin to be active there. And then, of course, I mean, general political advocacy around the absolutely urgent need for legislation to ensure access to birth certificates for everybody. We'll have to watch the legislation in relation to the exhumations. The previous general scheme that's been published is very worrying. It completely disapplies the powers of the coroner, doesn't contain anything about access to the actual files of your relatives. So we have to look at that. I think we absolutely need to repeal the gagging orders on the survivors of industrial schools who went through the redress board and deal with the 7 of the Mother and Baby Homes Commission Act. And then we have to augment the Freedom of Information Act. And then in policy terms, I mean, the government has to get its act together on GDPR. I'm still trying to figure out with data protection lawyers what the model is that we want to see. The minister said in response to our suggestion that it's not possible to have a dedicated unit of the Data Protection Commission that would give accessible information to people, that would decide appeals quickly, that would monitor the data controller's behaviour. But I've also been told that you can't usurp the powers of the Data Protection Commission by creating an ombudsman of some sort. So that needs to be figured out, because there's an absolutely huge job of work to be done there.
Thank you. Thanks.
I think with the media, when these things happen, there's, as you said, that gaslighting effect, or it's almost like a mansplaining in the media, seems to shut down a lot of the argument, the just argument for the families or people involved. So I think if there's clear statements countering I suppose the main government line saying, well, you don't understand, it's too it's too complicated, that's why it has to be seen. They give out these things, and then certain people that support certain parties regurgitate that narrative all over social media and everywhere. And it's very hard, even if you know it's gaslighting or mansplaining, to actually put your head around the ins and outs to counter that. So I think that's really important, to have clear media counters out straight when that happens.
And for all the professional organisations that can, and for the academic groups that can, to actually say their thing, and even if it's not campaigning, to actually state what the situation is, to give that support to the people affected, because it's a very lonely space out there, and the technicalities it's like a complete weaponization of the technical language and structures of law and archiving and all of it. You couldn't possibly, this notion that you can't unseal the archive because some of the women want their information to be private. You're like, that is not how archiving works. Sealing, the opposite, they're not a binary. Either you seal everything or release everything to the public. And so whatever it is that the people who operate in this sphere can do to counter, I think, that gaslighting. And I would not be saying gaslighting lightly, but really,
Yeah.
it's something else.
Can I ask you, Maeve, do you think they are afraid of legal action? You know, I'm going back to the Supreme Court, you know, that pitched birth mother against adoptee. Are they afraid of more cases? Is that why they're being so cautious, do you think?
I think they are afraid of the legal bill of personal injury cases, but actually you've just raised a really important point about the IOT and B decisions. This keeps being used as the justification for we can't possibly give everyone their birth cert. Now, that's not true. That decision didn't deal with whether legislation was constitutional or not, and it's very clear from Supreme Court rulings that where the Oireachtas legislates, it is entitled to create rules that may, in some some individual circumstances, lead to an injustice, or just are kind of blanket applications because they're entitled to decide to deal with a sensitive area of social policy in a particular manner, having taken into account all the evidence, and they have a presumption of constitutionality attaches to legislation. So my point is simply that the IOT and B decision was looking at an individual circumstance, not even of an adoption, actually, of people who haven't even been legally separated from their families. And what it did was gave a list of questions for the lower court to consider when weighing up whether to release identifying information. Now, that was not to say that the only way in the future in Ireland people can ever access their birth certificate is through a procedure of making them go to a hearing and having this weighing up. Actually, birth certificates are all public documents since the mid-1800s in Ireland, so there has also not been a reckoning with that. But the more important thing is that this February, the Court of Appeal issued a judgment in the case of Habte and the Minister for Justice, which found that it is an unenumerated constitutional right to have your identity correctly registered and used by the state. So that, I think, is really landscape changing. That case involved a woman who had become an Irish citizen by naturalization, and her certificate of naturalization had a wrong birth date on it. And when she realised her correct birth date, she asked the Minister for Justice to amend the certificate, and he refused. And the Court of Appeal ultimately concluded that the High Court had been right to say, and it had drawn on rights in the UN Convention on the Rights of the Child in relation to the right to have your identity registered, and also the ICCPR, that it is an unenumerated constitutional right because identity is so important to the protection of the person. So I think that's key.
I just want to say a huge thank you to you personally for all the work you're doing, because I'm one of the people affected. I am an adopted person, and so obviously I have a huge interest in this. And I would echo the earlier question, you know, what can we do? And I have seen some statements coming out recently, and my fear is he's still talking about this balancing of information. And I just wondered if you're hopeful, or are you having discussions with the minister? Can we be hopeful ahead of the publication of the final report into the commission, and what happens next?
Yeah. So the thing is that he recognises legislation is needed. Really, the GDPR is too blunt a tool to provide the guidance that everybody needs. And it also, in and of itself, doesn't recognise the context in Ireland, the injustices that were done. And what he is recognising, and we absolutely have to press him on, is the need to legislate to set up rules and procedures and clear pathways and efficient pathways and like principles around mixed personal data, maybe the types of categories that you get straight away, the types of categories that have to be balanced, because GDPR really can and is designed to allow whatever data controller to possibly reach a different decision than the next data controller, because they simply just have to weigh, and then if you disagree that they've weighed properly, you complain to the DPC, and it's all just not good enough for this enormous area of I suppose, censorship and secrecy that needs to be undone. So I was worried not to see in his most recent announcement about when he's going to publish the report. He had only, I didn't see reference to an immediate bringing forward of legislation on access to identity. He only mentioned that he would be bringing forward legislation on exhumations, and like it is beyond time to just legislate to make sure everybody can have their birth certificate. And then you can add into that other areas of information access, but it is not complicated. It is done and has been done for decades in Northern Ireland, England, Scotland, Wales, and many European countries. And I am worried, that it's still seen as this really complex thing. And I know, and you know that the argument is there are some women who do not wish to be contacted. But again, like I've argued, like a proportionate way to deal with the desire of some people not to be contacted, and I know that it is far more adopted people who don't want to be contacted according to the National Adoption Contact Register than their mothers. A proportionate way of dealing with that is to properly resource the Adoption Contact Preference Register, to make sure that it functions properly, to provide people with information about it and about their records and about the circumstances in which people might have been separated from their families while giving them the information. And until and unless the government accepts that argument that, yes, there are privacy rights on both sides, but you can interfere with them. You are already completely interfering with one side. You can do proportionately. It's not proportionate to not give someone information about who they are. It is proportionate to deal with the contact issues by facilitating people to manage their own family relationships, bearing in mind there is no evidence of adopted people posing any threat or being in any way worthy of discrimination compared to all other people in Ireland. Until they accept that, we're not going anywhere, because that is the stumbling block. They insist that mothers, and actually the 2016 bill included fathers, should be able to veto in certain circumstances people knowing who they are. And that is the stumbling block. And so, they seem to think it's just so complicated, and there was no mention of that legislation in the announcement of the fact that he's going to publish the report. So, I mean, the more people who can kind of participate in that debate, I certainly am working with lawyers. It just, it's very difficult. And there are many women speaking out, many mothers speaking out about the situation. I think there is fundamentally a lack of recognition and acknowledgement that adoptions were generally coerced in Ireland, and that two wrongs don't make a right, and that at this point it is incumbent on the state to step back from interfering in family relationships and to stop discriminating against people, and also to take that decision like was done when Germany decided to set up the Stasi Records Agency, which gives people full access even to things that other people did to them. That truth is the only way forward. It's the only form of accountability really that's left for most people.
I think it would be interesting to have an idea of the amount of money that the state and church made with these organisations too, and that's probably obviously something they're trying to hide as well. But I think it will be significant, because there has to have been significant earnings from
in the archives, like the financial records. And what has been constantly argued is that the records belonging to or held by religious, for example, you see this in relation to the Magdalens as well as mother and baby homes. We can't take them from the religious. They need to mine them because they all contain very sensitive personal data. And that's just not true. Like, the archives contain a lot of administrative information, and the same with the state's archives, because again, in this debate last month, it was all about how we can't possibly unseal the archives, because you'd think, to listen to the arguments, all it contained was the confidential testimonies of women who'd suffered, which it does, but like, that's not what people are looking to be published. What we want published is the administrative files, and that's the money trail. And I think there was a lot of money involved.
There was. I did a few interviews for community radio with some survivors that wanted to, I suppose, discuss it. But that's what struck me between the adoption sales and the hours that were worked and the objects that were made in the laundries, the amount of actual, it was like a factory.
Yeah.
That it has to be something that's in the narrative a lot as well, that it wasn't just somewhere to put people, that there was nowhere to put them. That amount of work that they did every day as well.
I think the regulation of charities is an issue, because once you have charitable status, it's not really possible to have such a thing as profit. So the Macaulay report found the nuns made no profit, but profit actually doesn't exist as a concept once you are a registered charity.
Right.
So, you know, money being surplus and going back to the order is not profit.
Okay. And you would see that with a lot of the HSE places right up to the last couple of years. They would have been making things with people that were institutionalized. And I find some of the areas in these buildings, they would still call them rooms, but they were, the names of the rooms are rooms that would have been making something for a hospital or for an organization. So I don't know, I think it is a huge thing, that this institutionalizing people as a community or society thing, when really it's a huge money. And then if, as we know, something becomes profit, well, then it's profitable to get more people in and keep them in.
Yeah, and the 1936 Conditions of Employment Act is really interesting to look at, because it exempted religious organisations from the obligation to pay wages to anyone who was detained in their institutions or institutionalised. Yeah, and actually in a case that I'm working on at the moment before the UN Committee Against Torture, brought by Elizabeth Coppin, who was in 3 Magdalens after an industrial school and a county home, the state is saying, as its defence, it's not responsible for what happened in the Magdalens, because it didn't regulate them as residential institutions. It only regulated them as ordinary factory premises. Therefore, it didn't choose to know what was going on other than the health and safety of the machinery. So there's a whole lacuna there of forced labour, and you'll see if you look into it that human trafficking and forced labour in Ireland are massive blind spots in terms of proper criminal justice response and regulation generally. Huge issues.
Sorry, one more question. I'm just curious about all of this kind of, I know it's going to be ongoing probably for a long time, but is there a point that you see this maybe transferring into history, into Irish history, as in for mainstream, for schools and stuff, you know, the part of our history? I don't know if that, or what organisation looks at that.
Yeah, I think if you look at the Collaborative Forum recommendations, you'll see that that was one of the big recommendations, that memorialisation should take the form of national education. And that certainly is how it is envisaged. Memorialisation is envisaged in international human rights law under the pillars of transitional justice, and also the notion of a comprehensive right to redress for torture and ill treatment. And it's very much linked to guarantees of non-repetition. So that's part of your right to redress, is to know that it won't happen again. And that means that memorialisation has to be connected to national education. And so that was a recommendation. Interestingly, the Collaborative Forum's report in itself, that was the basis for its recommendations. While the recommendations were published, the report was censored, and the previous Attorney General said it couldn't be published, and that is a huge problem. Again, it's just secrecy constantly. The Dublin Honours Magdalens Listening Exercise report is also so fascinating on this, and so myself and colleagues in Justice for Magdalens Research and Nora Casey organised a gathering of over 200 Magdalene survivors in the summer of 2018, because the Minister for Justice hadn't progressed the part of the redress scheme for Magdalene survivors that was a dedicated unit that was supposed to help them meet. And also Dublin City Council was planning to sell the last Magdalene to close to a Japanese budget hotel chain. We wanted to bring the women together, and they came together and were facilitated in tables of 10 by academics and others who are working in this area. And the listening exercise is on the website, report is on the website of Justice for Magdalene's research, and there's 1,000 pages of transcripts, and there's a report that summarizes it. And the women really very, very clearly say that what they want most of all to come out of this is for the younger generations to be educated. And there's some really profound quotes from their from the listening exercise, just around how they want their experiences to act as a guiding light, so that people can say, we've been here before, we have to stop and change what we're doing. And they reference direct provision as well, and also a lot around victims of rape and child victims of abuse and not being believed and listened to, and how that needs to change. So I think you can see it in principle in international human rights law standards, but you can really see it more through exactly what people say about what they want the outcome to be. And that's why it's so insulting, I think, for survivors to be to be portrayed, as they often are, as wanting money. And they actually, when they want to get to court, it is so much about accountability and making sure that someone is held to account so that it can't happen again. And accessing information is about like making sure that it's known, and it's about dignity. And there's the money issue is again, it's just, I think it adds further insult to injury. And I gave testimony to the Scottish Parliament a few months ago about how they're planning on putting in a waiver of rights into their redress scheme for victims of historical child abuse in care, that once you get money, you have to never go to court. And just made that point that just sends a message that people who actually don't have a choice because they need the money, that all they're interested in is money, because they chose that rather than exercising their rights to accountability. And because they're also, the Scottish government, as with our government, was portraying it as a choice. We're giving people more choice. They can choose to take the money, or they can choose to go to court. But of course, they don't have a choice. They need the money for the education of their children, for the heating of their house, for the repair of their roof. And actually, redress schemes like that, where you give a limited amount to everybody, should be actually about empowering people then to be able to choose to go to court if they wish to afterwards, because you can always legislate to make sure the courts reduce the damages by the amount already paid, if that's what you want to do. Anyway, so I know I can see here, I'm sure we've gone like way over.
I'm conscious of time, and that some people have started to go on. It's a hugely important issue, and we didn't even touch upon the issue of how come that unmarried mothers in the Irish state, they fell within the cracks of the law, right? All this coercion and forced adoption, and the coercion in the first place to put them in the Magdalene laundries and mother and baby homes, and then the forced adoption. That's a hugely unexplored topic, and that's something we could be talking for hours. I think it's the work you're doing now at the moment to redress the abuse right now. I think that's hugely important, because as you said, it's something that's still going on. It's not an historical issue. It's not something that happened only decades ago. It's still there with the people who are living with the trauma they experience. So thank you so much for all the work you're doing. It's really impressive, and how you can quote the different articles of legislation on the top of your head and you're so prepared and so passionate. So we're very grateful you were with us today. I'm not sure if there's any other, maybe somebody wouldn't speak yet, if they have any other burning question. Otherwise, I think in the interest of time, we're gonna have to close it. I don't know if there's any other comment, or just I want to thank Maeve for.
No, just well done. Yeah, well done.
Thank you so much.
Thank you.
I did warn you that I find it hard to focus on, like, it stands to reason. I mean, by 1951, over 1% of our population was incarcerated in one place or another. So it's huge, and we're only beginning. We're only, like, apologies are literally day one of the government recognizing something is wrong here. So yeah, we've many decades of work left to do, and thanks so much, Clodagh, in particular, for sharing that.
Yeah.
So thanks for asking me, Ciara, and keep up all of your excellent work, and hopefully we'll meet again.
Yes, thank you so much. And
Thank you.
there will be another session of the webinar in January with Erin Darcy, the founder of Inner Shoes. So we're going to continue the discussion about women and activism today in Ireland in 2021. Thank you so much, Maeve, and see you everybody. Bye-bye.
Bye.
Bye.
Thank you, Maeve.
Bye.
Bye.
Thank you.
Bye-bye.